presenters, Alan Johnston, Susan Watson-Bonner from the Financial Investigation Division, distinguished colleagues from the Betting, Gaming and Lottery Commission and the Casino Gaming Commission, media partners, distinguished attendees, ladies and gentlemen, good morning. It is my pleasure to welcome you to the Betting, Gaming and Lotteries Commission seminar, Reporting Requirements of the Terrorism Prevention Act for Gaming Lounges. I would like to thank the Financial Investigation Division for partnering with us on this important initiative and for serving as our presenters today. This morning, we're privileged to have with us Alan Johnston, who is the UK Technical Consultant from the Financial Investigation Division, and Susan Watson-Bonner, who is the Acting Director of the Financial Intelligence Unit of the Financial Investigation Division. Both will be presenting on what, when, and how to report the Terrorism Prevention Act. Ladies and gentlemen, terrorism and terrorist financing is a global threat. It not only affects our financial system, but of course it also poses a risk to democracy, rule of law, and human rights. There is no doubt that a global effort comprising international organizations, government, and private sector is of utmost importance to deny opportunities for terrorists and criminal groups to raise and transmit funds for their activities. In this respect, we fully appreciate the Financial Action Task Force efforts in promoting the international framework for anti-money laundering and countering financing of terrorism. At the local level, the Commission is fully supportive of the CFT efforts and have been working very closely with FID to raise the awareness of AML and CFT and to strengthen the knowledge of operators in the gaming industry. As new terrorist groups are formed, it is very important to strengthen understanding of the dynamics of terrorism and terrorist financing. We all note progress has been made in countering terrorist groups, including ISIS, Al-Qaeda, Boko Haram, Al-Shabaab, as well as their connected groups. Money for terrorism and terrorist financing appears indispensable. It therefore means that operators in the gaming industry have an important role to play in the detection and disruption of terrorist financing activities. From our vantage point, we have seen a growing effort to implement anti-money laundering measures. This momentum is encouraging. So, what are the expectations for gaming lounge operators? You must have robust internal controls, robust policies, robust procedures, and of course, your training of your staff is important to allow for the detection and reporting of suspicious transactions. The process must be risk-based. And in particular, we are looking for emphasis on customer due diligence, assessment of risk at the start of the business relationship, and of course, ongoing risk assessment and monitoring of your customer activities. Particular attention must be placed on high-risk jurisdictions. And in addition, you have to assess whether it is known or suspected that the customer may launder. Importantly, staff need to keep abreast and be trained to recognize the indicators of potential money laundering and terrorism financing. You cannot take your eye off the ball. Ladies and gentlemen, we have a considerable amount of work to do, both individually and collectively, to ensure we put in place efficient and effective policies and procedures to mitigate money laundering and terrorism financing risk. With that thought, I thank you for your attention and wish you a good seminar. Please join me in welcoming Alan Johnston and Susan Watson-Bonner, who will be our presenters. Thank you.
Well, thank you very much for inviting myself and Susan this morning. I'm just going to touch very briefly on terrorism in the round and really how it affects gaming, or probably, as I'll go on to say, how at the moment we're not aware that it affects gaming. And then Susan is going to deal with the, because she's far brighter than I am, going to deal with the far more technical elements of this. If we just move on to the first slide. The first slide shows us, this is what we'd like to be doing, thinking that we can discover everything. The reality is that quite often things happen without us really realizing. What we're going to be talking about today is trying to put the things in place that help us look at the first side of the cartoon rather than the second side of the cartoon, and getting ahead of things. Terrorism is a very pervasive crime. And what I'd just like to do, just to read it, the United Kingdom Terrorism Act defines terrorism as the use or threat of action where the use of the threat is designed to influence the government or to intimidate the public or a section of the public. And I think it's this use of threat, it's this use of violence, which makes terrorism such a frightening crime. And we've seen bombings, we've seen people run over by motor vehicles, seen stabbings, we've seen a lot of things. All these things have something in common, that they do require finance to start them off. The problem is that it doesn't actually require a lot of money to start them off. Probably the most famous terrorist act in recent memory was the 9/11 bombings. You may well have heard, relative to the damage that was caused, relative to the impact that they had, and the amount of planning that went into it, the total cost was reckoned to be $500,000. So that's less $500,000, but we're very much aware of the impact that that had. The problem that you've got, and I'll mention it a couple of times because it's very important from your context, is that terrorism financing is very difficult to spot. Because unlike money laundering, the sums of money are much smaller. And if you look at money laundering is the act of taking essentially dirty money that's been engendered through crime, and trying to make it clean. Frequently, terrorist financing is exactly the opposite. It's frequently, as we'll go and talk about in a minute, clean money that is then used for, if I may use the expression, a dirty purpose, the terrorism. So it's frequently very difficult to spot. But if we're bearing in mind, this is what we're looking at, this use of threat or action, and we can see the chilling consequences of it. Well, let's just put it in context. We've started to see, if you see in parts of northern Nigeria, Boko Haram are actually controlling large parts of the country. We've also seen it with ISIL or in Syria. So we've seen now that the growth of terrorism and the ability to exploit the vulnerabilities in the system. And so it's very, very important that we stop this. I don't think anybody would disagree with that statement, or I'd like to think nobody would disagree with that statement. There are many facets to this problem. I don't see any point in going into all of them today. I want to talk in the context of this audience and what we're here to talk about today. And we're talking really about the financing of terrorism. What we're seeing, as I say, we've got terrorists occupying large areas where they're able to control, so they're able actually to control what is going on in those areas. So what's happening? Well, we now find ourselves, and Laurie mentioned it in an address, and Susan will talk about it, because a lot of the reason that we're here is because Jamaica has signed up. It's got international obligations, treaty obligations, the FATF obligations, whereby we say, yes, we will implement these measures to combat terrorist financing. And in doing so, it impacts on all sectors of Jamaican society, of Jamaican business. So what you find is, in the busy regulatory regimes that you face, with all the red tape and bureaucracy, we add another layer as well, by saying now you have to concentrate on terrorism financing. And it's important, but I'll delay coming on to its impact on the gaming sector. Let's just talk about what I would say is the reality of the threat to Jamaica of terrorism. Okay, so it's a tier 2 threat. So what does that mean? It's deemed to be a low probability. Okay? But if it occurred, it would have a high impact. I think really the threat that Jamaica faces from terrorism is somebody with an AK-47 walking down the beach on the grill and finding a section that's covered with people who are my colour and raking the AK-47 up and down that element of the beach. Because if you killed 20, 30 terrorists on a beach in the grill, by the time you get the international reporting, the impact on Jamaica would be tremendous. And if you see it, there's some quite chilling, is probably a little dramatic, but very impactful photos of, there was a beach resort, I can't say it, Sharm Sheikh or whatever it's called, somebody know how to say it properly, but the beach resort in Egypt, and it shows it in, I think, in 1 year, and it's a picture, and it's full of people. Shortly afterwards, they had a terrorist attack. You then see the pictures, and it's deserted. Jamaica is very reliant on its tourist sector. So it would have a massive impact on us. So I think that's the main threat. But nonetheless, all countries face terrorism financing. There is always the opportunity. Because, as we know, when we try and stop criminals, when we try and stop people, we put something in place here only for people to pop up over here. And then we think we stop it there. So all the time that we're putting things in place, criminals are finding other ways around it. So if we just have a little look, this is normally where terrorist financing comes from. And this is what we're talking a lot of it about, is the main problem is the exploitation of the non-profit organisations within countries. Because a couple of things can happen. You set up a non-profit organisation, a charity, and what happens is people think that it's a legitimate charity and they give you donations. Well, what actually happens is, and what we see is the slide below that where we talk about sham organisations. What actually happens is this charity is intended, this non-profit organisation isn't actually going to help the starving children in Syria who've been affected by the activities there. It's actually a conduit for terrorists to get their money. To get terrorist financing is expensive and is costly, and what you have to do is commit different types of crimes. So yes, you do solicit donations maybe from people unwittingly, or frequently people wittingly do it. Frequently people commit crime so they can get the money that will then go on to pay for the terrorism. Now what we're seeing is obviously within the context of this audience, we see with gambling. This is where we have to be honest with you as an audience. At the moment, within the gaming sector, we're not seeing a lot of activity that is related to terrorism. But if I can just share a quick story with you. I play squash over at the Ligony Club, and last night I was talking to somebody, and he knows what I do for a job, and he said, "How's business? Are you busy?" And I explained, well, I first joined the police in 1980. It's 2018, and I've never stopped being busy over the last 38 years. And what you find is that it doesn't matter whatever you do, and this is why Laurie is so right, that we have to be vigilant about all these different regulations and being vigilant as a body, as the other bodies are. And the fact that everybody is here today shows the commitment to that. We have to be vigilant because I've found over the last 38 years, no matter what you do here, and this comes back to this, I don't know if you've ever seen that game where you bang something on the head here and it pops up over here. There's like a child's game. So in other words, whatever you try and do to stop something over here, it comes up here. So at the moment, and I say, it would be disingenuous to try and pretend that gaming is the #1 area of terrorist financing. A lot of the reports show that the main area that suffers is online gaming, and with casinos, online casinos especially. But that is not to say that tomorrow somebody won't discover something within the gaming industry that is actually a very good way to launder money, that is a very good way to engender terrorist financing. And that's why it's so important that we're honest about you, that you're not you're not at the forefront of it, but you could be tomorrow. Because my experience of the 38 years that I talked to my friend about last night tells me that when we try and do one thing, criminals think of different ways. There's a flexibility. And if you introduce regulations, etc., in one place, then they look to another. And as the world starts to apply the FATF regulations, they start to look for places where possibly they can get away with it. So they'll look to Jamaica. If we aren't vigilant here, if we're complacent, then we'll be perceived as possibly a weak spot. And then people will seek to exploit it. So this is why it's really important to say, no, when you look at it, the gaming industry isn't the most popular way of terrorist financing. It's certainly very popular for money laundering. And we know that money that is laundered and stolen, etc., and we'll give it a couple of examples in a minute, can find its way back to fund. But purely in terms of terrorist financing, it's not the most important way. These are the more common ways, and I think these will be the ways that you'll generally see how people acquire a crime. Especially popular with terrorists are cyber crimes. Because frequently, where the money is being raised is not where the money is needed. So again, this is why Jamaica has to look at its vulnerability. Because Jamaica, thankfully, is not a hotbed of terrorism, but it is a sophisticated society. It has good banking, it has good financial institutions, it has the infrastructure to allow it to be used and exploited by criminals who are in one country to send money to another country. And if we look at all of these things, they're just different ways. And I think what we have to do is say, yeah, we have to concentrate on terrorism financing, but we can't divorce it from the criminal origins. And I think sometimes we dress up terrorist financing to make it out to be something special. At the end of the day, it's a crime. And what we're asking you to be is your organisations being exploited for criminal purposes. I think we're not going to stay with that one. But just an example, again, this is more involving gaming sites because there's very little, because of the due diligence, etc., that you do, what you find is the face-to-face gaming isn't exploited in quite the same way. But like a stuck record, I sort of come back around and say, just because today we're not aware of it, it doesn't mean A, that it's not happening, or B, that it isn't going to happen tomorrow. And that's why in the world of law enforcement, we're very keen on typologies, and you'll see typology reports produced all the time. Because what you find is that in Jamaica, no, we haven't got that experience, but another country has had that experience. And when you then look at the experience of that country, you say, actually, I can see parallels here. That's very important. What we need to do is then look and say, well, this other country has had that. And actually, we can see certain parallels in the way that that country operates, the way that we operate. So it's very important. This just goes to show, even when you're in prison, it's not a barrier. So these three people were all imprisoned for encouraging people to join jihadist groups. They were the people, when you see people getting their heads chopped off and whatever, they would ensure that all those films were circulated. Because what you have to look at is with terrorism, there's different people committing, involved in the acts of terrorism. There are the people who have the guns, there are the people who strap explosives to themselves and walk into a busy marketplace and blow themselves up and everybody who's around them. But before they get there, they need people who are willing to do that. So these 3 men were responsible for that. They need to pay for all of this. And these 3 men were in part responsible for that. And if you just read the slide up there, basically, you don't need to have a credit card in your possession, but you can have all the information. Yeah, because we all transact online. If you've got the numbers written down, you don't need the card. Nobody's swiping the card. So what they were able to do was, using these stolen credit card identities, generate sums of money that are then used, and this was done through betting on the online casinos. As I say, it just goes back, that is where the weakness is at the moment, but there may be other ways within your industry that can be exploited, and it's important that we mitigate against that. Here's another one. And again, he was supposed to be collecting money for terrorism, and he spent a lot of time actually in casinos. Now, I know somebody who was actually involved in this investigation, and he was saying they followed him, they were doing a lot of work around him, and they never got to the bottom of what he was doing in the casino. But he said it was definitely related to terrorism financing. The point of this is, this final slide, and you'll be pleased to hear I'll be going, and you'll get Susan in a second, is I spoke to you at the start and said gaming is not the most prevalent area at the moment for terrorism financing. When I spoke to my friend about this investigation, he said it was clear that he was using the casino in some way, they just couldn't work it out. Well, what did we say before? We mustn't be complacent. And when the things that Laurie talks about and Marcia, and when they go on at you to do things and whatever else, it's because there's a whole international regime, and Susan will talk to you about the importance of it. But what it is, it's saying, we got the first cartoon, yeah? What we want to be in Jamaica, what we want to be in our various industries, is ahead, and we want to be there when we find that bomb, rather than watching the bomb go off. So it's a difficult job you have. You do have my sympathy, because it really is like trying to look for a needle in a haystack. All we can ask is for your help and support and commitment in putting in place the regulations that Susan's going to talk to you about. So thank you for your time. That's hopefully set the scene a little bit, and Susan will now take you through the far more technical bit. Thank you.
Good morning, colleagues. This is my Proceeds of Crimes Act. It is my Bible. And don't for 1 minute believe that you can call me and ask me anything about poker without me looking in the Bible. The good thing about an attorney is that we get to tell the client to come back, because we can go refer to the law and read what the book says before we tell you anything at all, right? So my portion of the work is the boring part, to tell you about the law. Now, for terrorist financing, the Terrorism Prevention Act, it is all over the place. You have a substantive legislation, then you have had several amendments to it, right? AJ started and he told you about your sector and the role you play. I call you colleagues, reason being is that you're all in the fight against money laundering and terrorist financing. And why do I say that? You work in a sector in Jamaica, which, as AJ said, is not a main sector for money laundering and terrorist financing, probably more money laundering than terrorist financing. But the fact of the matter is that we can't take anything for granted. Jamaica has several obligations by virtue of the fact that you know that one of the good things about being a politician is that you walk around and sign paper. So we go and we sign all the different treaties, but of course it is important that we sign these treaties. Why? Because we are part of a global economy, and therefore to be a part of the global economy, to be accepted in the global economy, to participate in the global economy, we need to say to the rest of the world that we are cognizant of the dangers and the ills that we face, and therefore we want to be, or we want to take active steps in making sure that the world is a safe place for all of us and for our children and grandchildren. So for example, Jamaica, the Financial Action Task Force, and that you'll hear people saying, FATF, it is the Financial Action Task Force. So therefore, like, I'm sure that some persons are not aware of it, I was not aware of it until I got in saying fathead, I thought it just meant somebody being fat with a head on foot. Right? Yes. Right? So I'm not here pretending. Right? So that's the Financial Action Task Force. Jamaica is a member of CFATF. So they add a C to the fat and the S, and they call it CFATF. What is that? Caribbean Financial Action Task Force. The Caribbean Financial Action Task Force adopted from FATF 40 recommendations. And one of those recommendations is that it's a risk-based approach. And so we must adopt a risk-based approach in our dealing with money laundering and terrorist financing. So what that means? It means that we have to look at each sector, sector by sector, and assess the risk that they pose in terms of being vulnerable to money laundering or terrorist financing. And so we are now in the process of doing our national risk assessment. And what it means is that from time to time, you might have persons, we'll go to the competent authority, which is the Betting, Gaming and Lotteries Commission, but we will also probably attend upon different entities to find out how it is that what are your procedures that you have put in place to detect terrorist financing and or money laundering with a view to coming up with a risk rating that will be attached to your sector. And so we have to do that kind of thing. Now, in terms of the law, in 2013, the government of Jamaica saw it fit and designated non-financial institutions. And what that simply means is that you're not in the business of carrying on financial business on a day-to-day basis. You're not like a bank or an investment company or anything like that, but you deal with some aspects of money because people coming to your place and them have to pay in order to play a game. Right now, I'm not pretending that I know anything about the gaming sector outside of the Terrorism Prevention Act, because the closest I come to gaming is when I go to the hotel, I look through the mirror like that. Because I have never won anything in my life, and I know I'm not going to win anything. So if I buy a grab bag and there's rubbish in the bag, I grab the rubbish, right? So that is my luck. So I don't take good money and chase bad money. So in 2013, you were designated non-financial institutions, and so you came under the ambit of the Proceeds of Crimes Act, which means that you have to make certain reports. So under the Proceeds of Crimes Act, you have to make suspicious transaction reports, and you can also seek consent to do certain transactions. Now, we're working out certain kinks, because I don't know when 100 Hope Road open at 2 a.m. in the morning, who at FID you're going to call to ask for consent to do a transaction when you see a man coming with 30,000 US and say that I'm gaming this or doing something like that. But we're working out the kinks. We're in this together. It came into effect in April 2014. So you are already, or should have already, been familiar with POCA and your requirements under POCA. Very well. In November last year, the law, again, of course, thought it was prudent to bring my colleagues further under the umbrella of the Terrorism Prevention Act. And so, in November last year, an order was passed for you to make reports under the Terrorism Prevention Act. And the law says every 4 calendar months you're supposed to make a report as it relates to a listed entity. All right, so this is the part I spoke about POCA being designated non-financial institutions, and that was November 2013, and it came into effect in November 2014. And the DNFI, which is a designated non-financial institution. So when you're out and you hear people talking, you can say, and them asking, why is it that your company have to do what you do? You can easily say, I'm a DNFI, all right? And you can also tell them what the meaning of that is. Not primarily engaged in carrying on financial business and designated as a non-financial institutions for the purposes of the Act, right? You now fall within the regulated sector, and therefore you are required to do what the regulated sector is to do. Because of that, therefore, you have some obligations. You have to develop and maintain policies and procedures, systems to prevent and mitigate money laundering and terrorist financing, and that is at section 18 in the TPA. Competent authorities for DNFI, and you're right there in the bright color. Gaming operators and your competent authority, these beautiful ladies that are sitting here, and their support team are your competent authorities. Listed entity report. When is it that you're supposed to file? Very well. The order was passed in November of 2017. And the law says every 4 calendar months you're supposed to file a listed entity report. And that makes you reportable June to September 2018. And the designated authority, who is the Chief Technical Director of the financial institution where AJ and I work, says that you have until October 31st to file your report. All right? So you have every 4 months, and you get up to the end of the following month to file your report. Now, where do you find your listed entity report? Summary of reporting obligations. So you have other reporting obligations which you're familiar. I just put a little bit of poker in it so that, just to refresh your memory, but it's not because I know that I don't think you know already. It's just for helping me and for helping you. So on the poker, it would be section 94, authorized disclosure and consent requests, section 100 subsection 4, and what this means is that for 104, anybody in the course of your employment, any information comes to you that you believe the person has engaged in money laundering or is about to engage in money laundering, you must make a report. So even if the person not talking to you, so you're out having a drink, or you hear 2 customers meet up in your business place and you hear them saying, boy, say, all right, this is the money that we're going to do. This is what we're going to do it. Gone are the days when you see I'm blind, ear and deaf. What we now do is that we do it in a professional way, right? So we do it where we remain undetected and there is very little or no threat to our lives or that of our families. But the see I'm blind, ear and deaf thing will work again, all right? For the safety of all of us. Who is a listed entity? What it says is that a listed entity is an entity included in a list of entities designated as terrorist entities by the United Nations Security Council. And all the bright people here knows how to go to the UN website and to look on the listed entity report and to see who are the entities that are listed as listed entities that are engaged in terrorism. And therefore, having done that, you now look amongst your record and to see whether or not you have any of those customers, and you now file a report. In addition, you not only have to go to the UN listing, the Office of the Director of Public Prosecutions, once an entity is listed on the UN website and the information comes to the purview of the Director of Public Prosecution, the Director of Public Prosecution under the TPA is obliged to seek an order in the Supreme Court, and once she satisfies the conditions set out in the Act, then the order is granted by the court. Once the order is granted by the court, then it means that the DPP now publishes within 7 days of the granting of the order in the newspaper, in a daily newspaper in circulation in the island, the order indicating which entity has been so designated. So you also have a backup system where you can, so in every entity here, I'm sure that there is one person who scouts the newspaper on a daily basis and cut out those articles and put them in a file folder. Anything to affect gaming sector, any new laws or taxes that are going to be implemented, and also anything in law that is going to affect your sector. So remember, the folder must be updated on a regular basis, and we must have someone who is looking out for articles and ensure that they are properly updated. And it says that the entities, and you guys are the entities, right? And the entity is not only an organization, an entity can be a person, all right? States that the entity shall determine on a continuing basis whether they are in possession or control of property owned or controlled by or on behalf of a listed entity. So therefore, you must do it on a continuous basis. So you don't just look one time, 1 quarter, and then you don't do it again. It has to be it is a continuing obligation, and the law contemplates that each entity will designate a person who has certain responsibilities. If you're not up to the task, when the boss said to you, you are going to be the person responsible, you're going to be the nominated officer, decline kindly. I know it comes with more pay and things like that because it's a big responsibility, but it is a fiduciary responsibility. And let me tell you, the penalties are onerous. Prison time are both money and prison time. All right? So you have to take your responsibility serious. It's not about to frighten you or anything like that, but let me tell you, it is serious. Right? It is serious. And it is more serious because Jamaica is coming up for its 4th round mutual evaluation under the Caribbean Financial Action Task Force. I just break to tell you this. What it means is that Jamaica will be assessed as to whether or not it is a good place to do business. I'll give you an example. Trinidad is currently suffering by virtue of the fact that Trinidad was placed on the CFATF list for enhanced due diligence. The only reason why Jamaica is not yet on that list is because our gross domestic product is below that of Trinidad and Tobago. What it means for Trinidad and Tobago, it means that for every US transaction, every foreign currency transaction they do, they have to pay like an additional $5.50 US or $7.50 US to get that transaction through. All right? Jamaica can't afford that. Up to Sunday, Trinidad, last week Friday, it was in the paper, Trinidad was placed on a list by the US as being facilitators for financing of terrorism. Right? Now, we know that the US is not, in and of by itself, one of those governing bodies that really people should be relying on in terms of the credence of certain information. But the fact of the matter is that by virtue of the power that the US plays in the world, then people are going to pay attention to it, right? And therefore, it means more consequences for Trinidad and Tobago, which is very close to us. So we have to think about that. Our economy is in a worse position than theirs, but the impact can be catastrophic. Obligations to file listed entity reports. And as I said before, it states that every entity referred to in paragraph 2, which is paragraph 15.2, shall report to the designated authority at least once every 4 calendar months or in response to a request made to it by the designated authority. Either, and what your report will say, either that you are not in possession or control of property referred to in subsection 2, or that you are in possession or control of property, in which case it shall also report the number of persons, contracts, or accounts involved and the total value of the property. All right? In making the report, the entity shall comply with the directions as may be, that should be given by the designated authority. So when you're filing your reports and you're taking the reports to the FID, what we are now seeing, people filling out listed entity reports, they have, and there's a slot where they say that they don't have any client who is a listed entity. But at the same time, them fill out all them name in the listed entity. So them fill out all they fill out their name and their address and everything, and they are the listed entity. It is not supposed to be that way. And what you do, when you fill out your report, you can fill out your report, complete the report, but you take it with a cover letter and a copy cover letter, so that we can stamp your copy and you can return your copy of the cover letter, so that when your competent authority comes and say to you, I would like your record as it relates to your filing, your compliance with the Terrorism Prevention Act, then you can pull out your folder, not the same one where you keep the clippings and everything, pull out your folder of copy letters in support of compliance with the Terrorism Prevention Act, and you also have a folder including copy letter of reports filed pursuant to the Proceeds of Crimes Act. And when you pull out your folder, you can show your competent authority all your stamped and signed documents from the FID showing that you have, in fact, filed with the designated authority. And you are clear to go. Tipping off. Now, what is tipping off? Unauthorized disclosures. So we know Jamaica is a small place. And we know gaming, first, I mean, you learn as you go along, because I thought that Jamaica had so many casinos. It's not until I spoke to these wonderful ladies that I realized that we have no casinos, right? That we have gaming lounges. So Jamaica is a small place. And we are a close-knit people, and we have friends all over the place. So the fact of the matter is that when you have filed your listed entity report and you realize that your best customer name is Michael James, but by virtue of his affiliation with a certain group, he's now Lakem Samaj. And please, I am not accusing the Lakem Samaj of anything. I'm just using it as an example because I don't know how to call any other name and to spin it around where it makes sense. So I'm just using it as an example. Please don't go and tell your friend, you know something? The boss wrote up a report and sent it down to FID about you. Right? You can't do that. All right? It is against the law. It is against the law. And let me tell you something, people, it is a real reality. When you work in these entities, you build a relationship. Do not compromise your professionalism for Christmas gift or for any kind of gift at all. What we have seen at the FID, and I'm a legal officer, my profession, my substantive post is a legal officer. What we have seen more and more is that, and I don't think it has reached a stage where it has developed into a trend, but what we have seen more and more is that when you go to, so you stop a man down the road and him have drugs, 7 pound of kilo of cocaine in him car. And when you go up to him house and you find, in one occasion you find, what, 5 million in the bathroom, then you ask, you have more? And then when you search, you find 2 million in the closet. By the time you finish, you find 18 million in cash. But somewhere along, in one of the bedrooms, is a nice little young lady who is doing law up at university because she's supposed to advise him on how do I do this, where do I do this, or she's doing pharmacist or something. No, I'm not saying that that is the case and that is what we're doing, but you have to rotate your frontline staff. You can't have people getting too comfortable with people and everything like that, so much so that it is okay. They now bend the rules and do everything because your entity becomes at risk. And it not only means trouble for the person who is becoming compromised, it means trouble for all of us, right? Because you can't feed your family, you're going to go home, the entity going to lock down, the entity is going to be blacklisted. So listen, we want good customer relationship and we want to maintain good relationship with our customers, but it must not be at the risk of our reputation, our character, and our entity, and our business entities, because Jamaica need the money, so we need the taxes, right? But be honest. Say no. I don't think that that is proper. I don't want to act that way, and therefore, you can stay if you want to comply. But if you don't want to comply, find a gaming lounge that is willing to facilitate what it is that you're doing. All right? Because when you walk out at night, you can walk forward, head up, back broad. And like, oh, my feet are not exactly small because I have to balance my body, but you walk comfortably out because you know that you are doing what it is that you're supposed to do. All right? So it's something we have to look at. Duty to report certain transactions. Now, you not only, under poker, you only have to report suspicious transactions. But under the TPA, you have 2 kinds of reports that you have to make away from your listed entity reports. And section 15.2a, B, and C speaks to the fact that you have to make report certain transactions. What are those certain transactions? This obligation for DNFI arises pursuant to section 16.2 of the, anyways, the TPA is Terrorism Prevention Act, which states as follows. The entity shall, in relation to each customer, pay special attention to all complex transactions, unusual large transactions, or unusual patterns of transactions, whether completed or not. So if the man come in and him start, and you're not comfortable and you approach him, and him say, you know something, I'm going to take my business somewhere else because I don't like how you just follow me up, or I don't like how you just talk up to me, because you know how it is. Then, even so, you still make the report, all right, where it fits within the criteria of that which the law sets out, right? And it says each entity shall promptly report to the designated authority all complex transactions, unusual large transactions, and unusual patterns of transaction, which have no apparent economic or visible lawful purpose. Now, gaming is a game of chance. So I am not so sure about the apparent economic or visible lawful, well, the visible lawful purpose, you're gaming, and it is and you're gaming within the law, but the apparent economic value, right? I'm not sure, because you can lose all your money, and I'm not sure. But it says, you in your capacity, and you would know. As I say, I'm not trying to insert myself in your industry because I don't know all the intricacies of what takes place inside, but this is what the law requires you to do. So therefore, you have to look, and where you need clarification, the law also says, speak to your competent authority. So these ladies know everything. So anywhere where I sound like I have a gray area, they will be able to make up for that, right? It also says, ensure that the background and purpose of all transactions referred to in paragraph A are examined and the entity findings thereon set out in writing. So therefore, you have to look at the transaction, and you have to detail what it is that you find about the transaction, right? And the legislation at 16.2bi says that you must make it available and upon request to its auditors. And I'm saying, and I'm suggesting that your auditors are your competent authority. Because in this case, the fact that you are reporting complex, unusual, large, and unusual patterns of transactions, I don't think that in terms of your financial activities where your auditor would want to verify your accounting records, I think this is more geared. The purpose, if you read the legislation in the spirit in which it was created and the purpose for which a section is designated, then the use of the word auditors might not be the correct one, but it should have rightly said that the competent authorities, right? So what they're saying, a law must be practical, right? It doesn't always sound that way to the ordinary man, but there is a phrase which says that you must read words around their ordinary meaning and take it in the context of what the section is saying. And in the context of what the section is saying, it could only mean that the auditors being described there has to be your competent authority. Duty to report suspicious transactions. All entities referred to in section 15.2a, b, and c, and this is where section A, B, and C speaks about foreign entities who are engaged in insurance business, investment, and all of that. Then it comes down to C, B, and then C speaks to entities so designated. And you would clearly fall in C because you have been designated by the minister, right? And what it says, you have 3 and 3A. Every entity shall report to the designated authority all transactions, whether completed or not, which the entity suspects or has reasonable cause to suspect involve property connected with or intended to be used in the commission of a terrorist offense. Now, and you must, in terms of suspicious transaction reports must be made immediately or at least 15 days after the suspicion has arisen, right? And in making it after the suspicion has arisen, you now have to give a reason as to why it is that it was not made immediately. Also, in making your suspicious transaction reports, it is your duty bound to give a reason as to why you're suspicious, right? Yes, the law don't say you must be sure so the man being involved in money laundering and therefore you must go follow him or try to listening on his conversation. But what are those things that have given rise to you being suspicious that the person is not just about gaming, right? There's something more to it, right? In taking a place as a meeting place, you see meeting up and everything like that. I was traveling with my husband one Christmas, and across from us was a gentleman dressed. I mean, yes, it's some form of discrimination, but he would have what you would deem a Muslim look, and everybody in the plane was looking around at the man. I thinking that this was going to be something like Christmas, and everybody started to pray. We all repented. We were about to write our will. It's just that we never know how we would get it to anybody, right? Because we never had any internet access at the time in the plane. But everybody was looking at, and every minute people were like, right? So what are those things that has given rise to you being suspicious and would want to file a suspicious transaction report? When you look at property has a you have reporting obligations under 2 laws, POCA and TPA. Under TPA, property is defined as money, tangible and intangible, personal items. So therefore, you might have a very good customer who decides that, I don't have the money today, but I want game, so hold on to the Rolex and top up my card. All right? So therefore, the Rolex is a personal item. Now, I have just learned in my job as many years as an attorney that you do have Rolex that value $50 US. All right? So therefore, when you see the gentleman come and flush out him Rolex, don't even be perturbed because it might just value 50 US. Right? There was a range person. Item seized from the gentleman, he had 11 Rolex watches. Right? So I mean, you know how the FID get excited because government was going to get a whole heap of money. Right? Because 11 Rolex watch? How could one person own 11 Rolex watch? Until we took them for assessment. The most expensive Rolex watch was 500 US. Okay? Right. So guess what? There's Rolex from China and there's Rolex. All right? So pay attention to it. But those things, so property is not only money. I don't know what operates in your sector, whether or not people can come with anything but money, or what do you use as a store of value for people gaming, but bear in mind that property is not only cash, all right? And therefore, if you are holding on to anything else for anybody, so if somebody has something that you're able to prove that is genuine, and the person has left it with you for an extended period of time and has not come back, then you might want to make a report, because if somebody has left their Audi outside, and no stewards or nobody not searching for it to come and repossess it, you might want to wonder what the situation is, because nobody leaves those vehicles unattended for a very long time, right? And so where a report is made in accordance with subsection 3 or 3, the entity concerned, its directors and employees shall be exempt from any liability to prosecution for an offense under subsection 4, 5, or 6. And listen, I don't bother write out 4, 5, or 6 what they mean, because you want to know. If you become suspicious, you file a report. If you have a listed entity on your business, you file a report. You don't need to go read subsection 4, 5, and 6. Once you comply with the law, then you are good to go. All right? I mean, I am still learning. I still have to look to the legislation to see what the sections mean. So guess what? You know what your core functions are under the law. Comply, right? If you need further clarification as to what a particular section means and all, it's always there. It's on the internet. You can look for it, right? So that's it. This is not an exercise in trying to get the law stuck in your head. It is to remind you that you have a legal obligation in law to report, and therefore, these are the circumstances under which you make the report, right? Unauthorized disclosure. See, come back up again. The law is very clear about it. Right? Save and except in circumstances where a matter comes up in your institution and you call your lawyer. You said to your lawyer, you know, this is what is happening in the institution. We have a client who X, Y, and Z. Then there is no breach for you to be disclosing to your attorney to get guidance from, advice from your attorney. I'm sorry, attorneys don't give guidance, they give advice, all right? Right, so you're obtaining legal advice from your attorney as to how to treat the matter to ensure that you yourself are not at risk of prosecution, or where you have failed to comply with the provisions of the law, then you might call your attorney, because there is a clause in the legislation which says that you have a reasonable excuse for not filing your report. There is nowhere in the law that defines reasonable excuse, but the reasonable excuse can't be that I never remember. So therefore, you might want to get some advice from your attorney as to how to arrive at a reasonable excuse, right? Because it is the court who is going to determine whether or not your reasonable excuse is sufficient to the standard that is required in law for you not to suffer the penalties of failure to file your report. Penalties for unauthorized disclosure, and it speaks to where you have save and except for the purpose of obtaining legal advice, or for the purpose of facilitating any investigation or proceedings that might be conducted in following that report. You commit an offense, and for the purpose of, right, it sets out that and it sets out the penalties. In the case of an individual, a fine not exceeding $2 million, or to imprisonment for a term not exceeding 2 years, or to both fine and imprisonment. Okay? So, therefore, and if it's a body corporate, the fine not exceeding $6 million. So remember I said initially that it is not a walk in the park. You have to take your obligations and your responsibility serious. When you are entrusted with big responsibilities, big things are expected of you, right? So we have to take it serious. Regulatory controls. When we look at regulatory controls speaks to those things that the entity must do. So therefore, when you get a job, your boss can say to you, go read up the POCA and the TPA, and this is what you have to do. The law prescribes that certain steps are taken to inure to the benefit of not only you as an employee, but to the benefit of the entity as a whole, right? Every entity referred to in paragraph A to C, that's before, and A to C sets out, remember A to C sets out the financial institution, the other institutions, and the DNFI comes at C where the minister designated you, right? Shall, and in law, shall means you do have an option. It is mandatory. It is mandatory, all right? If not mandatory, right? Shall establish and implement such programs, policies, procedures, and controls as may be necessary for the purpose of enabling it to fulfill its duties under Section 15 and 16. And what you must know, Section 15 deals with listed entity reports. So right away you know, under the TPA, your new obligation, Section 15, listed entity reports. If you don't have any listed entity, then you file a report which says that I don't have any account with a listed, I don't have any listed entity report, any customers who is on the listed entity report. And Section 16, 16A deals with reporting of certain transactions. 16.3A deals with report of suspicious transactions, right? So in the TPA, it's relatively close and it's relatively simple, for want of a better word, as to what your obligations are and to what you are to report. Section 18.2, without prejudice to the generality of subsection 1, the programs referred to in that section shall include, and remember I told you that we have certain fixed things to do, so that's one of the manifestations. The establishments of procedures to ensure high standard of integrity of employees, right? The development of a system to evaluate the personal employment and financial history of those employees. Now, I'm happy that I don't work with any of your entities. I am a civil servant, because if B applied to me, then government would see, then your entity would see that once money coming to my account and I'm on time from government, all right, finish. Same time. So they would be wondering how I live to see the end of the month. Thank God I'm married. All right? If for no other reason, thank God. But the fact of the matter, you see what your employers have to do. They have to ensure high standard of integrity of employees, and they have to look into your personal financial history, because what the law supposes, and it is, I don't know that it is fair, but the law is not about fairness. It is about justice, right? Because look, for me, yes, I will spend everything that is mine, but it doesn't mean that I'm going to spend anybody else's own, right? So the fact that you spend off all is yours, it don't mean that when the person comes in, you're going to turn a blind eye to what the person is doing, and you're going to take people's money and to compromise yourself and to compromise your entity. But this is what the law says that your employers must do to ensure that the organization enjoys a certain level of protection from the likelihood of money laundering or terrorist financing. Because what do those people do? They find a soft spot within every organization. And therefore, when they find a soft spot, and what people think, and people have this myth now that they say, them people thief because they're poor. Well, I don't know how many, and I'm not seeking to determine people's affluence or how you grow. But I know most of us were poor. It never, me the poor, it never met me thief, right? And thank God, my mother has 6 of us. And she said, make them fire no for feisty, but not make them fire no for thief, right? So guess what? It don't make us thieves. But the rule is, and the law is, this is what your employers have to do. So therefore, it can't be that your employer sees you with the card that you put the person's money on. When the person gone home in the evening, you have the card, right? You have the card, and therefore you have access to be doing whatever it is, right? You have to maintain that line of demarcation between your work, your commitment to an organization, because when you take the job, you commit to maintaining a certain standard, all right? So do what we all must do. Regulatory controls again. Now, I got where you fail to file a report. So we have entities that fail to file reports. And therefore, you're supposed to send in the name of the entities to the DPP, and the DPP will determine whether or not she will prosecute. And I get a report from a noted credit union. I received training under POCA, but I didn't receive any under TP, and therefore, I did not know what to do. Don't be one of those entities. Train your staff, right? A little of the resources that you get. I mean, I know the resources are dwindling, but use them wisely. And therefore, in using them wisely, that should include training for your staff. Nothing builds loyalty to an entity more than people who are well-trained. They feel good about the business. They feel good about themselves, and they want everything to go right because they know that when things go right, boss treat us right. Okay? Yes. So for you, the entity shall consult with the competent authority. And again, I repeat, your competent authority, guys, is the Betting, Gaming, and Lottery Commission, right? And any entity which contravenes Section 18(1) or 3, that means you don't train your staff, you don't implement the policies and procedures that you're supposed to implement to gear your staff and to arm them with the requisite knowledge and training for them to do the job adequately, then you have committed an offense, all right? And therefore, any offense under TPA, they're all criminal offenses, right? And therefore, the law treats with it in a particular way. AJ, in his part of the presentation, spoke about terrorism and terrorists using amounts, small amounts. Now, the legislation speaks about the minimis amount, and you're not required to report certain transactions. But I don't want to say that is a lacuna in the law, or I don't have any information now that that is being, amendments for TPA are currently in train. I don't think they have reached cabinet yet, but I know that they're still with the Attorney General's chambers. That was the last update I got prior to coming here from Foreign Affairs, who has oversight of the Terrorism Prevention Act. It speaks to small amount, but in our case, and I don't know what obtains in your industry, but the fact of the matter, for me, I think, for me, 250 US is kind of enough money. So even if, because sometimes you don't have somebody all using 3,000 US dollars, but the fact of the matter is that small amounts build up. And therefore, if and where you think that somebody is using small amounts to avoid detection or to stay right under the radar, then over time, a series of transactions can build up. And so you could also make a report. Yes, you're going to indicate it's a small amount, but what are your reasons for believing that this transaction is suspicious or it is an unusual pattern of transaction? Probably it used to be that the person would not have spent this amount, but you notice over time the transaction pattern has changed, and therefore you want to, it gives rise to you making a report. It's better to report than not to report. I mean, we need to have quality reports, suspicious transaction report, because personally for me, I think a good suspicious transaction report is one where it can almost establish a prima facie case. So by the time I get your report and I read the reasons and I pass it on to the investigators, it means that they have sufficient where they can go complete an investigation and we can prepare a file for the legal unit to proceed with a matter to court. But report. To whom should you report, right? And the reports must be sent in a sealed envelope, packages, stamped confidential, and addressed to. I mean, fine, if you don't have a stamp, it's okay, you can write on confidential, all right? I don't think that it's not so critical. To the designated authority, Chief Technical Director, Financial Investigations Division, Ministry of Finance and Planning, 1 Shalimar Avenue, Kingston 3, right? And prior to 2013, as I said, that the TPS had several amendments. Prior to 2013, the designated authority was the DPP. Now the legislation has been amended, and the designated authority is the Chief Technical Director of the Financial Investigations Division. The law also speaks to relevant authority, and where you have relevant authorities, either the FID or the Chief Technical Director or the DPP in those circumstances. But for the purposes of the report, is the Chief Technical Director. Knowing your customers, right? Now, I'm sure that when persons come into your entity, they don't just, no? Am I sure? I'm not so sure. But I would want to believe that people don't just walk up to a gaming machine and without more, I just start playing. I'm sure I want to believe that there are some things that I would need to do. I would need to speak to somebody. I would need to present an ID, and I would need to do some things. Am I correct? Okay, very well, right. So what are those minimum things that you must do in order to establish a relationship with a client? And that is what? When you see KYC or CDD. So KYC, know your customer, and CDD is the same thing, you know, customer due diligence, right? So that's what it means, right? So you have updating your information. So you have clients who are repeat clients and everything like that. They might change their address. They might change whatever information. They might change ID, or their driver's license might become expired, the last driver's license that they had presented to you. You must have a period of time over which you review your data, just like how the bank will call you and ask you to provide certain information. You must have procedures in place where you review and make sure that you keep current information on file. And the law also stipulates a period of time for which you have to keep the information. High-risk clients, relationship, and these are PEPs. And politically exposed persons. It's not the PEP that I'm going to do on a G, to replace GSAT here, because it is also PEP. I wanted a list, the FID wanted a list of PEPs, because who are PEPs? So you have foreign nationals who are working in Jamaica, they're PEPs. The POCA speaks about ministers, in parliamentarians who are from both houses of parliament, so the upper house and the lower house. So the upper house is where is the Senate, and the lower house is where you get voted in and go. So all of those persons, and not only them, but their spouses, their children, and some of their relatives and their associates, right? So if you're associate to any politician, you know when Jamaicans like to align themselves with people of certain ilk. So when you go into the bank and the bank says, do you know so-and-so? Yes! It's not a good thing, right? Because if you know him now, you have to start declaring certain things. Yes, I know the Minister of Finance. He is my neighbor, right? So be careful how you answer yes, because it means something else, right? It now means that you have to be treated in a particular way, all right? So therefore, when the person is a PEP, right? And as I was saying before, I sent a letter to the government office and I said, if you have a list of PEPs, the FID would love to benefit from a copy. If not, do you know any other entity of government where we might get one? And the person sent back a letter and said, please explain the meaning of PEPs. All right? So we are yet to get the list, okay? But all your counselors, your caretakers, and all those people's police officers above the rank of superintendent, Assistant Commissioner, you also have persons in the Army above the rank of captain, right? Above the rank of captain. And there are some other persons. But you can find that in Section 7 of the Proceeds of Crimes Amendment Act 2013, where it tells you the list of all the PEPs. So again, POCA 2013, Section 70, and it lists out all the persons who are PEPs. So where those persons coming to your organization, it means that you have to take a little more effort to find out information about them, right? So we come back again, what is the Know Your Customer and customer due diligence programs, and it sets out, it is a cornerstone of an effective AML CFT program, right? Therefore, the NFI sector must implement procedures to obtain the record, CDD identification information about each client before engaging in business with them. And identification requirements, one form of ID required, current passport, driver's license, nationality issued identity, card or a card, that's supposed to be card, or a citizenship card issued within the country which a client is resident. So your client might not be Jamaican, but it means that the law also covers those means of identification that you can use to satisfy the requirements, right? And it is not to be an expired ID. A lot of people turn up and them have an expired ID and them insisting why it is that you must still accept the ID. I've been in lines and see people trying to negotiate with people to take an expired ID. It's me. You don't see it's me? Yes, so that's right. So we know how people can be difficult. I hope that by virtue of the industry area you would not have any of those difficulties. Now we continue with our CDD requirements, and CFATF and FATF recommendations, client identification and verification must be completed before a relationship is established. And so through your competent authority, I'm sure that those measures are already taking place. We continue again with the customer due diligence, know your client, required in situation where whether the person is doing a one-off transaction, whether the person is just coming to your entity for one time and you may never see them again, it does not take away from the fact that you still need to have some information about them, some customer information about them, right? You might not have all that you have on your on a client that has a continuous business relationship, but you need to have something, and that's what the law says, right? Verification method. Are you required to verify information that you get from your client? And it speaks to confirm residential address, confirm date and place of birth, and I mean, if you're going to use passport or identity card, confirm physical identity of client, and it speaks to beneficial owner. I am not sure how often, I mean, I don't know if you have professional gamblers where therefore it means that I would be gambling and would be gambling on behalf of somebody else or whatever those circumstances. I come with John Brown card. Can I use somebody else's card? No. Can't? I'm not supposed to? No, you're not. Okay, fine, I'm not supposed to, right? Yes, that's the operative term, not supposed to. Something like that. So, so those are things that we look on. In circumstances, you might find that do happen, right? And again, we go into the customer due diligence, and the reason why we have gone so in depth in it is because it is going to play a substantial role in how you identify and detect persons that you might want to make reports on. I mean, you might get, what we find now is that people are using, we had a case where the son and the father had the same name. And what we would see is that the son had two IDs. So one bore the name, one bore his father's information. So he had a picture on his father's driver's license. So he had a driver's license which bore the date of birth and everything of his father. Not sure, because I mean they were not like 10 years apart. And then he had one with his own personal data on it, but he used them interchangeably because we were able to get them from the bank when we serve the production order for documents from a financial institution. So it is something that we have to look forward to. And your regulations, your POCA regulations, tell you a lot of where you can, what it is that you must do in terms of your customer due diligence information and your know your customer regime. And the requirements are similar and would cut across both legislation, TPA, and POCA. Enhanced due diligence, where you have to deal with PEPs, and I'd mentioned it earlier before, then you have to go with enhanced due diligence. And what enhanced due diligence means is that what you do for me, who is not a PEP, PEPs also include persons who hold certain positions in government entities. So like chief technical directors, persons to the level of permanent secretary, or if you are not called a permanent secretary, but you are employed to a government entity and at a certain rank, then you are also deemed to be, if at a rank equivalent to that of a permanent secretary or a chief technical director, you might be a PEP, right, Laurie? Yes. And it tells you about, so here's a list of it: head of state, head of government, a member of any house of parliament, a member of the judiciary, right? An official above the rank, military official above the rank of captain, and a member of the police force above the rank of assistant commissioner, permanent secretary, chief technical director, or chief officer in charge of a ministry, department of government, executive agency, or statutory body, right? And the list continues. And it is because of the due diligence that you're doing, the initiating or the initial know your customer questions that you would ask your clients, that you'd be able to determine what it is that they do. Summary obligations for DNFIs. And when you look at all that you have to do in an overview of what it is that we have been saying, you are a regulated business, and by virtue of being a regulated business, it means that you have certain obligations that you have to do. So you have to conduct ongoing AML, CFT, and what that means is anti-money laundering and counter-financing of terrorism. File reports and required by the competent authority, which is your entity, the Betting, Gaming, and Lotteries Commission. Keep proper client due diligence for all your clients, and update your information. POCA speaks to 7 years interval on, based on the risk of the client. I don't see a year in terms of TPA, but it is geared mainly in terms of financial institution, but it is what it says. It's what the regulations say. Report suspicious transaction reports to designated authority under the Proceeds of Crimes Act. Under the Proceeds of Crimes Act, you also have threshold transaction reports, and we have the very vexed issue of dealing with Section 101A, which is not accepting cash of over $1 million for any transaction. Save and except in circumstances where you are a permitted person, and gaming entities are not permitted persons. Or, if not a permitted person, where you have either sought and obtained from the minister an exempted transaction. And I don't know, but I don't believe that any such entity in this industry have sought and obtained such a permission, right? So you would not be accepting that kind of cash for a transaction. Screen staff. Well, before that, you have established, implement programs, policies, procedures, and controls as may be necessary to prevent money laundering and terrorist financing. It is something that we have repeated continuously throughout the presentation, and it cannot be overstated, and so I have no objection to saying it again, right? And for continuity, what persons could do and to assist newer members of staff coming in, you can establish a standard operating procedure or just set out a guideline where your competent authority gives you the presentation. You can just look for those slides that speak specifically with section 15, 16, and even 18, and have those readily available to your staff from time to time, I mean, when I'm going to have prayer in the morning, before I start gambling starts, and you have the first word of prayer, then you also have a reminder. You have another member of staff talk about it, just to ensure that that member of staff also becomes affair with it. So at different times, you have different member of staff. You take a 5 minutes out of the time, and you do it for reinforcement and to ensure that persons are learning. And in your orientation processes for new employees, you also do it. Screen staff and train them in anti-money laundering measures. Avoid tipping off about money laundering or terrorist financing disclosure or investigation in either, right? Again, tipping off is very important, right? I mean, just your change in demeanor or how you deal with a client can say to the client something is not right, right? Worse if the client knows that something is up with them, right? So at all times you have to try to remain professional and to ensure that nothing you say, right? Well, the law speaks about actual saying, but I mean, no hints, all right? No hints. File your suspicious transaction report, file a threshold transaction report, making authorized disclosure and request for consent. Yes, you have the authority to make a request for consent. File listed entity reports, filing of suspicious transaction reports, and everything comes within POCA, if not POCA, TPA. And our focus today is the Terrorism Prevention Act. And you have section 15 and 16, which tells you about your reports. Summary of penalties. The body of the presentation has the penalties, but we give you a summary, right? So that you can see and to appreciate the seriousness of what you do, the role you play, right, in a sector that is critical to Jamaica's financial system and to the viability of Jamaica as a whole. Every cent in taxes, we know how much we need it, right? And so your role cannot be underestimated or diminished in any way, right? So it's not about just getting up and going to work, or it's not just about another job and I just go because of the money. You have real responsibilities and expectations of you, right? So when you look at money laundering, right, where you fail to make a report of money laundering. So you have a staff member, so you have been designated as, under section 18, the law speaks about nominating an employee as a nominated officer who makes the report and to whom reports can make. So a member of your staff comes to you, a colleague on the floor comes to you and says to you, I believe that this gentleman or this lady is doing something that is not consistent with the nature of the business we do. Something is wrong. But you fail to do anything about it, right? That employee can take it further and say, I reported so-and-so. Remember, for a suspicious transaction report, you're supposed to file it as soon as reasonably practicable or within 15 days after the suspicion came to your attention, right? And you have to give reason why. If you don't do it, then again, you might be subject to some penalties. Further, your competent authority might come in and do an examination of your records, and based on what they see, they believe that certain reports ought to have been made, right? How they treat with it, we'll see where it goes, but don't take your obligation lightly. DNFIs to a fine not exceeding $5 million. Now, a lot of DNFIs are small, relatively small entities. Therefore, a fine of $5 million could really render some people incapable, right? When you look on conviction before a circuit court, now the resident magistrate court has been changed to parish court. And parish court have limited jurisdiction in terms of fines, save and except where statute prescribes. And in this case, it's the statute which says the fines that they can charge. When you go over circuit court, which is down the Supreme Court, where you have to go downtown, you notice the fine is unlimited, right? So therefore, all of us could be out of a job. So take your obligation seriously. Unauthorized disclosures tipping off, right? And in terms of individual, fine not exceeding 1 million or imprisonment not exceeding 12 months or both, right? Disclosure to a person in the regulated sector. I'm not even sure what that is saying, but again, we see it. I don't recall. I can't see in the corner and say what it's saying, but disclosure by a person other than a person in the regulated sector, and that's what the penalties are. Non-disclosure by a nominated officer in the regulated sector. So where you get the report as a nominated officer, you don't do anything about it. That's what the first one is, what the fine is, or fine and imprisonment, right? And if you go to circuit court, fine or imprisonment, not exceeding, and you have 10 years, right? So by the time you come back out of prison, your child graduated from university and don't you remember, all right? Serious business, right? Yes. So 10 years in the life of any of us is a long time, right? So you have to take that into consideration. And the penalties continue, right? So that. Penalties again, you have more penalties, and the penalties just ongoing, right? It speaks about undertaking business as a shell company. And again, some of them, everything here may not be applicable. However, it is what the law says. And so I don't know if a key person in a company might have an account with you, but I know of a fact that an entity in and of itself, a shell company, it have to be a key person in an organization who turns up. But the intricacies of how you would deal with the last one, undertaking business as a shell company, or undertaking or facilitating dealings with any company of a nature with a shell company, it is something that I'm not sure that is readily applicable to you, but it is there for information purposes, right? In your business, what a lot of financial institutions do and are required to do is to assess each client and to give them a risk score. And so it is there. Conduct a risk assessment of your current client base and begin to assign a risk rating to your client. So whether or not you consider a client to be low, medium, or high, then it is something that you can look for. 2017, the FID got 115,000 suspicious transaction reports. I mean, no, it is onerous because, I mean, with an analyst unit of 4 persons who all 4 are never ever there at one time, you can imagine what kind of analysis we can do of 115,000 reports. Suffice it to say, we have seen an increase in the number of reports coming in from entities in the gaming sector. And what we have seen, and again, an assessment, and the reports are done based on an assessment of clients. And I say this to you because you are in the sector, and so you need to know what is happening. For one example, a person is a civil servant, and we know, and we all know, that government is not the best paying employer. But what you have seen is that a person goes to a gaming lounge within a year 284 times. And fine, 284 times can mean 3 times for the day. But the fact of the matter, that is someone who is spending over $300,000 US gambling. Right? And the losses are in excess of what it is that they are gambling based on the record. Right? So if it is that you are complying with the provisions of the law and the regulations, a client who is, that I would consider that person a customer. If a person, because we're looking at a 1-year period, and the report is in excess of 1 year, but for a 1-year period, 2016 to 2017, the person visited 284 times. I would consider that that person is a customer who you can adequately place a risk rating on, assign a risk rating, and determine whether or not that client is a low, medium, or high risk. All right? The report is filed on the basis that they don't believe that the person, the legitimate income of the person matches the gambling pattern of the person, right? And this is someone who is fine in a gaming sector, right? Now, when you look at that kind of analysis, because I have presented to you the fact that I'm a civil servant, and the person has the thought to mind to say that it is not consistent. right? And that, I think, is a very good effort. And we have seen a number of them and an increase in them, right? Develop an AML manual to guide, I'm sorry, it's not attorneys internally, but your employees. And it is something that we have spoken about before, right? And we have some attachments, and that is what your TPA form will look like, since we are focusing on TPMs. The form as it is right now does not allow us to online change the date, because all the other reporting entities, at the time when the reporting requirements started under the TPA, the entities started to report May to August, and so September was the end of it. So if you were to go in the form, you would not have been able to change that. But it doesn't matter. You can do the rest of the form, complete the rest of the form, and then you strike out May 1 to August 31st, and you put in June 1 to September 30th, right? But the form is there as a guide, and you'll have that to look at and to see how it is that you properly complete a TPA form. The order to have you report under the Terrorism Prevention Act, it was approved on November 29, 2017, and it came into effect 6 months after, right? This is the order, and you have the Gazette over there, right? So again, it's just for information purposes. You print them off, you put them in a folder, and just so that you have a hard copy, so that people can look at and to kind of familiarize themselves with it. Knowledge is power, and therefore you can't suffer from knowing what it is that you need to do, what it is, and why you do what you do. When people have a basis for knowing why it is that they do, rather than just doing it by rote, then they have more appreciation for what it is that they're doing. So it's just some more law. Not saying much, even though you see all the writing, all it's saying is that the law says that you must report under the TPA, Section 15 and Section 16, and you must do it 6 months after Parliament has done all of that, right? And that is what it requires. Now, thank you. AJ and your competent authority will answer all your questions.
Folks, we just want to thank Suzanne for all of that. It's a mouthful, and I'm sure there are a number of questions. So the floor is open for question and answers right now.
I just want to ask, once you're a PEP, do you always remain a PEP?
There are aspects of our 2013 amendment which seems to suggest that, which does not differentiate as to whether you are no longer a minister of government or a member of parliament. But we had asked for an amendment for it to be in line with the Financial Action Task Force PEP, definition of PEPs, which after a certain number of years, you're no longer a PEP.
How is it that you as a worker report a customer? How is it that you as the worker being protected?
By the very nature of the fact that you have made a report, you are protected by law. The law says that you're not exposed to any civil, criminal, or administrative penalties by virtue of making a report. Not all you might be the one making the report to your nominated officer, because the law contemplates that each entity will designate a senior person. As a matter of fact, the law says at a management level, if you look at Section 18. And so once you make the report to that person, then it means that the person is supposed to report. You give the person the basis as to why it is that you feel that this, but yes, you do enjoy protection in law from reporting, because neither you nor the person to whom you have reported is supposed to disclose it to anyone else, save and except the designated authority. So not even other persons within your entity are really supposed to know about the report that you have made.
Okay, thank you.
You're welcome.
As a follow-on from the question that was just asked,
Yes.
what, if any, protection is there from victimization of an employee who may file a report? So you're protected under law, but is there anything that can protect that employee after the report has been made from being victimized by the entity or the manager or somebody else?
Well, that seems to be an issue for employment law. What I can tell you, though, I mean, it definitely would be, because the law in and of itself does not provide any protection outside of you're not disclosing, and if somebody discloses, then the penalty to the person. But if it is that the person can prove that they made a report, genuinely made a report, and the fact of the matter is that the law also states that where you make a report in good faith. So therefore, even if you make a report on me, and the report does not inure to any criminal penalty against me, but at the time when you made the report honestly believing that I was engaged in money laundering or engaged in terrorist financing or about to become involved, then there is no penalty for you. But I mean, as I go back to repeat, it seems like that the person would have a cause of action in terms of wrongful dismissal or victimization, whether or not the employment law speaks to victimization, then that is where the person would definitely have to go. I can give you an example. AJ and I were in the UK recently where we did presentations at the 36th Cambridge Symposium, and there was a gentleman there who used to work with Royal Bank of Canada in the UK, and he made a report on the bank that the bank was engaged in money laundering. Suffice it to say, he's out of a job and he's in court with the bank. So you can imagine a one individual in court with a bank, right? Suffice it to say, the UK legislation provides that where you have made, and he did it under whistleblowing, under the whistleblowing legislation, but there is, if he succeeds, and when he explains to you, you don't see any reason why he should not succeed, even though, I mean, I can't foresee how much more he can go with a conglomerate as opposed to an individual who has now become his own attorney at law because he doesn't have money to pay. But the fact of the matter is that the whistleblowing legislation in the UK provides that whatever the value of the amount that it is that the bank is, the institution is liable for, then the person who, the whistleblower, gets a percentage of that amount. So I'm not sure what our whistleblowing legislation says or if there is any benefit, because you have to balance what benefit you give with persons arbitrarily coming up with stories and things like that. But no, I'm sorry, there is no legal protection against somebody who makes a report and the organization decides or the entity decides that you have gotten rid of one of my best customers, right? So that's it. We would hope that persons would operate at a professional level, and therefore the employee will be taken to be doing their job professionally. Yes. Mm.
I would also like to add that when a report is sent to the nominated officer, after assessing that report, should report directly to FID. They do not or cannot inform the board of directors or the managers the name of the person that was reported to FID and to whom, because they can be charged for unauthorized disclosure. So there is your protection. Your breakdown, if there's a breakdown, then the nominated officer will be the person that you can look at, because they're not to inform the board, their managers, or any of the senior team, okay?
In the case of the terrorist financing list that Trinidad has been placed on, is there any coming back from that? Can they repair their image and be be taken off that list?
Yes, the challenge with, yes, I believe that they can, but the challenge with that is that Trinidad seem to have, or not seem, they have active cells in terms of terrorism, and they have a number of persons who have gone to Syria and have come back to Trinidad, and so that is a real concern to the international community. So yes, they can come back, but I don't know if, so fine, we're Jamaicans, and even if you go to Syria, at what stage does Jamaica say, all right, you can't come back, the fact that you have gone to Syria? So, I mean, you will always have your nationals who do whatever it is they want to do. But as a country, if it is that Trinidad were to do sufficient and I'm not sure what sufficient is, even though I use the word, but sufficient to and in the view of the international community, that they're taking all the relevant steps to show their dissent towards terrorist financing and towards terrorism, that they could not be deemed to be taking sufficient steps to dissuade that kind of behavior and conduct, and could redeem themselves. But as it relates to them being placed on the CFATF list for enhanced due diligence, I had mentioned earlier that Jamaica, the only reason why we were not placed on the list for enhanced due diligence was because of the lower level of our gross domestic product. But also, you can place on the CFATF list for enhanced due diligence where you have gotten a partially compliant rating in 20 of the recommendations, and we have gotten partially compliant in 20 of our recommendations. So even though we are not, we can be recommended by another country. So another country can recommend that Jamaica be placed on the list for enhanced due diligence because we have gotten this amount. So when you're placed on the list, it doesn't mean also that you are doing anything wrong, or it means that your AML, CFT regimes are probably not as strong as they're supposed to be, but not that you have taken any active step to facilitate money laundering or counter finance or terrorist financing. But by virtue of that, by virtue of being placed on the list, the international community views you as in a particular way. Your financial institutions might be de-risked, and it has a whole lot of, it poses a whole lot of challenges. So it is important that for the fourth round mutual evaluation, which is coming up, that we try to enhance or to do better than we did in the third round. And so we can't do it without all our partners in the sector. And so consider the role that you play and the fact that you do have an impact on what happens to Jamaica and how Jamaica is seen in the global world.
The Protected Disclosures Act of 2011, Section 10, speaks to that kind of protection for the employees. They can actually forego making the disclosure within and come directly. Yes. So if you feel that you will be victimized in any way, you can go directly to FID.
Yes, she can, but I got, and thanks for that, because I did not refer to that act at all, but I got the impression that she made the disclosure and then she was victimized, but not on the basis that she thought she would be victimized, but having made the disclosure, she was victimized. But thank you so much for your kind assistance. Yeah.
Could you explain the minimis amount? I know that once a transaction is over $3,000 or equivalent to that amount, then enhanced due diligence is done. But I have seen a 250. Is that a new law?
No, it's not a new law. It is a part of the Terrorist Prevention Act and the Proceeds of Crimes Act. And what the law is saying is that where a transaction is $250 US, or its equivalent in any other currency, then you need not make a report, right? But our history has shown that some groups use small amounts of money because over time, small amounts of money do add up. They don't attract the kind of detection that large sums of money would. So while we're saying that the law says that you need not report where a transaction is deemed to be a de minimis amount, a small amount, an irrelevant amount, an amount that does not warrant your making a report, because the law probably looks at the practicality of it. If you were to report on 250, you can imagine the amount of reports that you would be making, right? But I would say that where you believe that a customer is structuring or smurfing, doing transactions to avoid detection, then it might warrant a report. But the law says where the transaction is of a certain value, and that being the amount, then you need not make a report. So it's different from where you have your $3,000 US or thing like that. It's like having a flooring where the law is saying that you don't have, if a report is this amount or below, you don't need to make a report on it, right? But you do also have a ceiling.
gaming lounges be required to cross-reference against any international list of known terrorists? And if so, which list, in which jurisdictions will local gaming lounges be required to do this?
Well, you're required to look on the United Nations list for the listed entity reports. Robin Sykes, who is the Chief Technical Director of the Financial Investigations Division, is also the chairman of NAMLAC. And NAMLAC is the National Anti-Money Laundering Committee in Jamaica, Jamaica's National Anti-Money Laundering Committee. And he, in tandem with the Ministry of Foreign Affairs, have developed a list that is more user-friendly than the UN list for those persons who have gone to the UN list and have tried to see what the listed entities are. When I had dialogue with the senior legal officer at the Ministry of Finance last Friday, that list was ready and it was sought to be done and obtained on the basis that you would have a wider cross-section of Jamaica using the list. And the DNFIs were in contemplation when he requested that that list be done. So you will have access to a more user-friendly list. Unfortunately, I'm not able to say that you will get access to the list tomorrow, but yes, it has been done, and communication will be made with your competent authority, and that will be communicated to you as to how you access the list once the list is ready. And what we will be done is that once the DPP gets an order, then the list will be updated so that when you access it, you are working with what is current.
Okay, thank you.
You're welcome.
Good morning. What I need to find out, a person who come into the gaming lounge and they actually the threshold, as I mean, it's like 250 US. But this person is trying to slip below the radar. So they come in and they put on like 180 US. They are gaming. So that wouldn't be, we wouldn't have to report that because it's below the radar. But what they are doing, we realize that this person comes in and come in several times for the day. They come in several times for the day, but they put on 180 US dollars. But we realize that this person is not the type of, based on the KYC rules, we know that this person, their job is probably a chauffeur. And what this person do, maybe 4 times for the day or 5 times for the day, put on $180 each time they left. Should this be reported, despite it's below the radar? Should it be reported as a suspicious transaction report?
Remember, I spoke about earlier structuring. And even though the law says that where a transaction is 250 US dollars or below, you need not report, you have set out clearly circumstances which would suggest structuring. So somebody comes 4 times for the day, and yes, it might be a chauffeur, but it depends on who is chauffeuring. If he's chauffeuring me, then of course, then it means that you would not be able to come 4 times for the day. But if chauffeuring somebody else, then he might be able to. But the fact of the matter is that you have given a good example of what structuring could be. So yes, in those circumstances, when you take the entire circumstances as a whole, right? And that is what the law is about, right? A one-off situation in and of itself might not give rise to a suspicion. But when you take the 4 transactions, you look at the nature based on, you said based on the KYC information that you have, the gentleman is a chauffeur. So when you put all of that together, now if you're a chauffeur, is it that you just drop off in the morning and then you pick up in the evening, or is it that you're supposed to be driving from point to point? So what is it that he does within the lapse of that time and everything? So you put all of that together, you do your suspicious transaction report, and yes, in those circumstances, I would say to you, yes, report. Right? That sounds like a classic case of structuring and that you'd want to make a report on.
Thank you very much.
Right.
When you make a report, how soon does the FID or the competent authority go after the bad guy? For example, a money launderer.
So yes, it's not the competent authority, it's a designated authority. In terms of the Financial Investigations Division, the Financial Investigations Division has a number of units within it. So we have the Financial Intelligence Unit, which is the repository for all the reports. Having received the suspicious transaction reports and all the other reports, we are now supposed to analyze and present you, the industry, with trends and typologies, and you will get some in the near future, okay? Then we have the Constabulary Financial Unit, which is a unit, again, within the FID, which is supposed to be, its core function is supposed to be treating with money laundering and issues of financial crime. When you send us a report, and it comes to the FIU, we do what we call, we assess the report, we look if there is value, and it is sufficient for us to do what we call a case disclosure. We do a case disclosure and we send it to the financial investigations team, who now puts some more meat, I'm sorry, you see that at hungry time and a lunch time? Meat, right? Some more meat on the report that we have gotten. And once the FIT team, which is the financial investigation team, does that, then where they think they have sufficient, they now pass it on to the police. Now, remember, we have over duplication of tasks, but where you file your report with us, that's what happened. But you can also have the fraud squad, you can also have, you have MIT, you have NIB, you have several other entities within, and every police officer is an authorized officer, and therefore money laundering is not only confined to the FID, but once you send us your report, we do a disclosure and it goes to the police. You know, sometimes your investigation does take time, right? So there is no, I can't say to you that within 6 months you'll have, the matter will be concluded and you will have somebody convicted, right? And I mean, I can give you a practical example as an attorney at law. We currently have a matter before the court where things are happening that we have never seen before. So this is somebody who we believe is engaged in lottery scamming, even though he has received limited amounts from persons, because to date he has only received 4,000 odd US from overseas recipients. But what we have seen are persons who are close to him who have received substantial amounts. So you have persons, he has even recruited persons, victims in the States, who are now receiving monies for him. He sends those monies to Jamaica. And when they send the monies to Jamaica, and when the monies come to Jamaica, they have now established links with lottery. So when you did a search was conducted at this place, and you found like 1,000 and something lottery tickets. Now, 734 of the lottery tickets amounted to $6 million and something dollars. In 1 month alone, he collected 20 million in winnings from the lottery company. Now, no reports were filed. Reason being is that when you present to the bank $20 million from Supreme Ventures Limited, as far as the bank is concerned, there's nothing suspicious about it because you have won the lottery. The fact of the matter, nobody at Supreme Ventures, when he presented 1,000 lottery tickets, thought that, how could I have one person with 1,000 lottery tickets purchased from several different companies, agents around Kingston and St. Andrew? Oh, you're so lucky, right? How is it that one person could be so lucky? So even though any entity in Jamaica who within the course of their employment sees a transaction that they believe can amount to money laundering can file a report. So the lottery company could have filed a report under 104 of POCA. No report was filed. But when you look at the distribution of the lottery tickets, 73% of the lottery tickets were purchased in and around St. Andrew. 23% was purchased in St. Ann, where the person is also connected. And another, like 3 or so % was purchased in Westmoreland, which is unrelated. But I say that to say that you have to know, so intelligence has shown him coming from a company, from a lottery company, I see him coming out with a bag. So what is it that we're supposing? We're supposing that he makes a link with the agents. The agents now pay you when you come with your lottery ticket. Instead of running it through the system, they pay you at a premium, take your lottery ticket, gives him, they get the money, they get some money, and he takes the bag with all the winning lottery tickets and present them to Supreme Ventures. Now, this is something that we have not seen before. So this means this is not something that, this is not an investigation that is going to happen overnight and you're going to readily charge. So you need to line up all your ducks in a row. And one of the challenges that we have had in Jamaica, and one of the challenges we have had as a country, even in terms of meeting our obligations under the Caribbean Financial Action Task Force, is that we don't have enough money laundering convictions. Number one, we are not sure when is money laundering, because money laundering is in relation to criminal property, right? So the fact that you have stolen my money does not make my money criminal. Right? It means that it must have come from something criminal. So at the time when you get it, it's criminal property already. So you have to line up. And what we have in terms of our police officers is that sometimes we arrest and then we investigate. And that is why a lot of our matters don't go where they want to go. So if we take our time to investigate and have all our ducks lined up in a row so that when we go to court, we know what it is that grounds an offense, we know what it is we need to prove to the court, then it is more likely that we will get a conviction out of that matter going to court. So again, we try to act as soon as reasonable practicable, but sometimes the investigation does not lead where we want to go. And the fact of the matter is that a lot of our criminals don't leave trails. Cash don't leave trails, right? And that is why they like to work in cash. So when you have someone in, and we have thousands of them, persons who are engaged in lottery scamming. And when you look and get a report from the remittance companies, you see a student of 17 years old getting $8–10 million from victims overseas. But what does he do? He buys a car in somebody else's name, right, that you can't trace the car to him. And then when rain falls in Montego Bay, him take a $5,000, wipe off the car windscreen and dash it away because him not need it. And buy champagne and wash him car. Right? So you find him with clothes and shoes, but you don't find him with anything else, right? And you can't even, and I'm going to build a house on land that the government would even make sense to recover it because nobody's going there to live, right? So you don't have, they do it in a way where sometimes prosecution is difficult. But if it is that we have the right kind of scrutiny within your organization, and the suspicious transaction reports are so good, they give you a pattern of what happens and everything like that so that we can properly build up, we can link them to other persons, then it's easier to launch an investigation and to establish a prima facie case that is going to ultimately lead to a conviction before the court. But the system is not all perfect, but we are doing, I want to say we're doing the best that we can. There's always room for improvement. All right?
Just some clarity on tipping off. Does that just affect one individual person, the individual person that has done the tipping off, or that has to do with the entire entity?
Tipping off can be the one person that, and for me, tipping off is more likely to be a person than an entity, because unless an entity publishes something, I don't see how it is likely that an entity is going to be tipping off somebody, but it can be anybody within the organization, right? So you're the nominated officer, you go home, the boss has the key to your desk because he's the boss and everything like that. He looks in your drawer and sees a copy of the report that you had filed, and he now calls up his friend and said, my employee filed something on you down there, and things like that. Who has the key? He knows. Who has the key to your desk, right? So it can apply to anybody in the organization. The law does provide for where the tipping off is done by a corporate entity. So I guess there is some possibility. But for me personally, the reality, it is more realistic for a person to do it than an entity per se. Right. I mean, I can see key personnel within an entity, but that's it.
Thanks.
You're welcome.
if a gamer is banned from one casino for suspected money laundering, for example, he's presenting fake ID, and he's banned from another casino for the same thing, and another casino for the same thing, sorry, gaming lounge, is there a way that all the gaming lounges can ban this one person?
There should be, because there is case law which says that because a person lies, it's not always indicative of guilt. But the fact of the matter, where you have persons actively taking steps to produce a fraudulent document, to a measure of identification that is readily used by most Jamaicans, then it is the clearest sign you can get that something is wrong. So if all the gaming lounges, and I mean people in industries, I assume that persons in the industry are talking. So even though we're sitting at different tables, I am assuming that the person who works up at the gaming lounge at Ligani can call out the person at 100 Hope Road and everything. So therefore, it's a close-knit environment. So therefore, you can ask your colleague, do you see so-and-so, right? And it's a business. So, in the sector, we talk, right? So that's it. But yes, if it is you're doing your KYC and you recognize that someone has presented fraudulent documents, then that's a red flag for you. You don't want to do business with you. But the fact of the matter is that the person might turn up somewhere else where they think that the KYC requirements are not so stringent. But I'm sure if that person too detects, then yes, by all means, the person should not be able to do business in any gaming lounge in and around Jamaica, not by virtue of the fact that they have money, because it's more than doing money, and then you can do business with the persons who have legitimate documents.
Good morning again, everyone. It is my pleasure to join you today in the closing of this seminar on terrorist prevention reporting. During the last 2 hours, we have heard 2 insightful presentations from the designated authority, whom have provided you with a reservoir of information and measures to guide against terrorist financing activity in the gaming sector. They spoke about what, when, and how to report. They spoke to the DNFI designation, the regulatory framework, your KYC and CDD requirement, as well as your regulatory obligation under the Terrorist Prevention Act and the Proceeds of Crime Act. Tipping off, which is an unauthorized disclosure, customer due diligence, enhanced due diligence, and of course, your regulatory controls that the organization needs to implement, and finally, summary of the penalties. I would like to thank Suzanne Watson-Bonner, Acting Director of the Financial Intelligence Unit, and Alan Johnston, a UK technical consultant to the FID. They have taken time out of their busy schedule to engage and educate the gaming industry. In addition, this event would not have been possible without the support of the Communication Department, Tamara, Jeanette, and Grayson. I would also like to thank the legal team that is sitting there, Director of Legal, Carla Dwyer, and Shoshana Carr Rodney, and Cleveland Allen for their usual support. And of course, the rest of the BGLC staff. Above all, I would like to thank you for making this seminar a success through your active participation, especially during your question and answer session. The objective of this seminar was to ensure that you understood what is terrorist financing. And as was mentioned, terrorist financing refers to the act of accommodating or facilitating financial transactions that may directly or indirectly relate to terrorist activities or terrorist organization. Of course, another objective was to look at ensure that you understand who or what is a listed entity. And as was mentioned, a listed entity can be a person or an organization. More importantly, we look at the requirement of the submission dates for the TPA report, which is very important. The reports you're required to report to the designated authority once every 4 calendar months, or in response to requests made by them. So, between January to April, you're expected to report by May 31st, on or before May 31st. Between May to August, you're expected to report on or before September 30th. Between September to December, you're expected to report on or before January 31st. So this is very important. Our work here today is not done. As we, the Commission, will continue to have dialogue with you to provide guidance through the implementation stage of your TPA framework within your organization. Again, I would like to thank you all for coming. Please note that all participants of this seminar will be presented with a certificate. Again, thank you for your participation. Have a great day.